Welcome back. We're on section 4 of the Divorcing a Business Owner or Entrepreneur webinar brought to you by O'Neill Wasaki. My name is Michelle O'Neill, and I am joined by Jere, Hight, and Ryan Segal, who are both attorneys at my law firm, and we're also honored to have Robert Bales, CPA, with us today. So this last section, we're talking about post-divorce issues and how to move forward when you represent a business owner. So there's some things that are kind of going on that are new and interesting. So, Robert, kick us off on what's going on new and interesting in the post-divorce business owner world.
Well, new and sad, I think, is the way I would refer to it. The Tax Reform Act had a provision in it that's really made it more difficult for us to settle a case involving small businesses. Prior to the passage of the act, we could use contractual alimony contracts to move pre-tax income from one spouse to the other to move the value of the business over.
So in other words, just so in case there's some young whippersnapper out there that wasn't around before the Tax Act, we would commonly award the owner of the business, and then award the other spouse some contractual alimony instead of like a payout or a loan, but used contractual alimony to offset the asset.
Correct.
The major asset.
And the business owner could deduct it, and the recipient would report it as income for tax purposes, which made it much easier for the business owner to pay it. And because of the differential in tax rates that normally occurred, had the government ended up paying part of our settlements.
Right. And it was an incentive to business owners.
It was a huge incentive, and probably the most common way we settled these cases.
Yeah.
The Tax Act did away with that for all divorces after December 31st of 17 or 18. 18,
yeah.
I mean.
Yeah, so starting January 1st of 2019, there is no more tax-deductible alimony. You can still have alimony, you just can't deduct it.
Unless you were grandfathered in.
Right.
So if you were grandfathered in...
So grandfathered in is any divorce that was finalized before January 1st of 2019.
Correct.
And there was supposedly a rush across the country in states that had better alimony rules than ours, in Texas, of getting divorces finalized to take the advantage of that grandfathered in.
There was a rush in my practice. I know that.
So now, in 2019, under the new rules, we can no longer use tax-deductible alimony payments to offset that type of dividing of the asset.
Correct. And the business owner's having to use after-tax dollars at a very high rate normally.
Yeah.
And it's making it much more difficult to equalize these estates.
So what are some things that people are doing with that?
Well, the riskiest thing I see, and I'll let y'all speak to it legally, is continuing to own the business post-divorce together.
Right. So, Jere, how do you go about that? Let's say that there is this business, it's community property, maybe even jointly owned, but it doesn't have to be, and you're trying to get this case settled. Business is the main asset, and you just can't agree on selling it or dividing it. So we're all going to own it together going forward. How do you do that?
Well, the simplest way to do it is you simply award 50% ownership interest in the entity to each spouse. Now, that gets the job done in dividing the ownership entity. Unfortunately, it doesn't address any of the headaches that are going to come up down the road. And, I mean, if I was going to do that, I think I would negotiate an operating agreement as to what this new business is going to look like, so everyone's staying in their lane. And I would contractually create some obligations between the parties so that they're fiduciaries of each other going forward, because the fiduciary relationship between the spouses ends at time of divorce. And if it's a corporation, the shareholders don't have a fiduciary obligation to each other legally.
Right. So let's walk through that a little bit more precisely. So spouses, when you're married, owe a fiduciary relationship to each other.
Right.
When you start in the divorce, probably no fiduciary relationship in the divorce process, but it's a little bit of a gray area. And then at the conclusion of the divorce, the spousal fiduciary ends. So what you're saying is that then there's also no fiduciary relationship shareholder to shareholder in a corporation.
Correct.
The shareholder owes a fiduciary relationship to the corporation itself, to the
Correct.
entity, but not to a joint shareholder.
Now, there is a fiduciary duty between partners.
So the rules are different in partnership.
That's right.
But in a corporation, shareholder to shareholder owe no fiduciary relationship. Why is a fiduciary relationship important?
Well, because without it, to put it simply, so you can sue the other shareholder for breach of fiduciary duty. And where it comes up is you have distributions, okay? You have an S corp, and let's say one party also is really doing most of the operating and getting a salary out of this corporation, and the other one is not, or a de minimis salary, and is relying on distributions. That's the value that person's going to get out of the corporation. Well, it might be good for the corporation not to distribute any of the money and to keep it in and to purchase more equipment or whatever, or make that decision. Well, if that's the case, then, and you're an S corp, both parties are going to have to recognize the income on their tax returns. They're going to have to pay taxes on that money, even though it never comes out of the corporation. Mm-hmm. So you've got one party that has the ability to pay those taxes through their salary, and if that party can control whether it's distributions or not, the other party has no income stream from it, but does have the liability of making those taxes. It's phantom money. And that's a terrible position to have your client in. I mean, they're getting no benefit out of this ownership interest. And so you want to avoid that.
So Bob, Robert, what are, you got me doing it now. Robert, what are some strategies that you recommend to people that find themselves in this situation where we're going to have to co-own a business after the divorce? What are some strategies that you can kind of recommend to avoid as many problems as possible?
That's a tough one, because my experience with these arrangements has not been good. The best thing you can do is make sure there's total transparency in financial reporting, and
maybe third party do the financials.
Third party do the financials and make sure both sides see the financials, that both sides see cash positions of the company. That general ledgers are made available so you can see where the money went. And if you can't read one, you can at least hire someone to read one for you. Oversight's very, very important. What happens is one party's used to running the business the way they have always run it. And they're not used to having partners, is what my experience is. And they don't make the transition well. So you've got to have forced transparency so you can make sure they're doing things appropriately. Because I would anticipate in most cases something inappropriate is going to happen. And you're going to have to build in procedures to take care of that.
Yeah. So when we were talking about the fiduciary duties, some of that is kind of a trust. Like, how much can you trust somebody? So a fiduciary relationship is designed to give you at least some comfort level that you ought to be able to trust this person more than any old random person on the street.
They have a duty to deal with you fairly.
Yeah.
That's the main thing.
And one thing that I've done in the past is bring in the attorney for the business itself. Because if you bring in that person, then you've got another individual, and you can, talking about the agreements that you make in a settlement or something like that, and they can help with that aspect. Because not only will you have, both sets of attorneys in the divorce, but then you'll have a new quote neutral third
Right.
party that's representing the business
Right.
that can help out with that.
And if the business is owned by both of these people, then that corporate attorney really should be somewhat neutral. I mean,
Right.
better not be aligned with either side, or there's some problems.
Right.
Yeah. So what about strategies for partnerships? You know, the rules are a little different for partnerships. So what if we're going to continue to own a partnership going forward? There's some pitfalls to that.
Well, we have an old case that one of my former firms had been involved in, and they did an arrangement like that with a partnership. And they started out with lots of millions of dollars, and she ended up with every bit of it. About 25 years later, he ended up bankrupt. In every case, there was a suit for breach of fiduciary duty, and he lost every one of them. So with a partnership, if you're the one that's running the business, you better be careful, because you do have that fiduciary relationship.
Yeah.
But again, I think you still have to have the transparency, the financial transparency, so it can be monitored.
Well, and it, you know, just kind of the bottom line to me seems like if you couldn't get along and do what was necessary to stay married, like how in the world are you going to get along and be able to, you know, accomplish what needs to be accomplished to run a business together?
One thing I've seen, and I sound so negative about this, but I do have an active a case we settled 3 years ago, and it's working well. And it's the husband doesn't live near the business. The wife runs the business. And there's a third-party relative who's a very, very savvy business person who is a tiebreaker.
Gotcha.
And I don't think they've had to use that tiebreaker yet, but the knowledge the tiebreaker's there seems to make it work.
Yeah.
So maybe you bring in a third-party tiebreaker in if you can find someone who's got the guts to do that. And in this case, it was kind of a natural. But I think it's working because husband's not physically nearby.
Yeah.
And he's still getting his cash flow.
Right.
That's the key.
Right.
is
So he's
getting
kind of
benefit
just
out
the
it.
non-controlling profits interest, and she's
Right.
running the business.
Yeah,
then.
technically they have the same amount of control, but she runs the business.
Yeah, yeah. And they're, you know, she's obviously, you know, doing what she should do rightfully by him. So that's a good thing, but that's just not, that's not super
unusual.
common, right?
It's not.
So, okay, so you mentioned bringing in the corporate attorney. A lot of times whenever you have these situations where the business is going to go forward owned by both spouses, I mean, sometimes the corporation is already a party to the divorce lawsuit. So sometimes you already have the corporate attorney. I've had a lot of situations, you know, where we have the corporation coming in as a party, and we as the divorce lawyer, maybe for the spouse who owns the business, have to be careful that we don't get in a conflict situation by offering advice to the corporation or to the individual as the corporate officer as opposed to the individual as the individual. So having that third-party corporate attorney, I think, is a really, really good idea.
Absolutely.
And they can also draft the paperwork.
Yes, yes. I was about to say they're going to do the BizOrg docs, and as you pointed out before, if it does, because and when I have the corporate attorney, one of the things I have to fight against if I don't have the client who runs the business is, well, they're aligned, and in my experience, that's not normally the case. So having them overcome that fear. But like you said, as soon as that other person gets an ownership interest in the corporation, you have the beauty of a fiduciary, another level of fiduciary duty owed by the attorney,
Right.
which should give some comfort.
Yeah, should.
In my experience there, in fact, when we were at a break, I shared with you one I have going right now where
Yeah.
we have a major problem. And I'm the company CPA, and the company
Yeah.
attorney and I are truly in the middle. And he's not taking any sides. I'm not taking any
Right.
sides.
Right.
So, you know, and I think both sides trust both of us. And that seems to, maybe we'll work through this problem. But yeah, he's not taking any side at all, and I'm not seeing him
That's my experience.
the end of it
I
all.
mean, normally they're not willing to risk their license or anything like that. And they're
No.
usually trying to do the best they can for everybody.
Right, they feel a duty
For the
to that
corporation.
company.
Yeah.
No, the
Yeah.
problem arises when you're taking apart their articles of incorporation or something that they drafted.
Yeah.
And then they're trying to defend that. That's gets in a little gray area.
Yeah, definitely. So what about receiverships? Sometimes we have situations where receivers are appointed over businesses, both in the divorce context, and then I think you could also have it in this type of context, right? I mean, so those can be problematic, right?
As one who has been receiver on several occasions, I would strongly suggest not doing it unless it is the last resort.
Right, because it's going to tank the
It's
value.
going to tank the business. It's probably going to trigger due on sale clauses. It's probably going to have all the loans called in
Yep.
under the nervous Nelly
Right.
clauses in the loan agreements. Customers hate it. They run for the hills.
Mm-hmm.
People don't pay the receivables because they know it's a receiver.
Yeah.
It's problematic.
Problem. So let's say you have a couple of a husband and wife, they co-own this business, they decide to exit the marriage but still co-own the business, and you get a year down the road and it's not working. So what are the alternatives? I mean, let's first assume that they are both 50-50 owners and they both are active control. What are their options? I mean, what can you do?
Sometimes you can draft in buyout provisions for that.
And I would suggest having buy-sell agreements
Right.
going into the
Right,
process.
right,
Right.
because most people realize trust is low at the end of divorce, and it could blow up. So hopefully that's already in place. So then it's just executing that. If I mean, someone's got to buy the other person out. Is
Yeah.
the thing. But
So that could be a place where the value at the time of the divorce might have been a valuable information to have, even if we're going to go forward co-owning
Yeah, but in this case, you're going to be buying them out
at the current value.
without regard to the personal goodwill.
Oh, so that's the
So
different
you're
value method.
Yeah, it's a different value, and you're probably, and this is another thing to consider in the construction of your agreement, you're probably going to have non-compete agreements and employment contracts in place
Right.
to protect the business, which nullifies this personal goodwill problem. So the value is going to typically be higher, but what you can do is name the terms and conditions of how you pay it and pay it out of cash flow.
Yeah.
I-
So you
and,
can.
I mean, you're still going to have the problem though of a 50-50 ownership of who's going to be doing the buying out.
And you got to have a buy-sell agreement that allows that process to take place. Could be a bidding process. I mean, I've seen them where it's a bidding process.
Well, and at that point, if you're operating under the more normal non-divorce method of valuing the business, I mean, maybe it's just easier to value it and sell it, and everybody take their money and go do something else.
Yeah, that happens.
Yeah, I mean, it just seems like, I mean, I understand why we're in this predicament, because we now no longer have this tax deductible alimony option to deal with. And so we have people that are just, there's maybe no choice. There's not enough cash, not enough assets for one spouse to take the business and the other spouse to take something else to get to a just and right division, so that you then still have this co-ownership problem. But it just seems fraught with so many problems.
It is. Now, one thing we did in a case recently, we had the couple had acquired an interest in a business, an additional interest into what they had, and they had some debt for that acquisition debt. So they were loaded up pretty good with debt at the time of divorce. So what we did is we put a put option in the agreement where not he, because he's running the business, but she had the right to put it to him when that debt's paid off.
So tell everybody what a put agreement is.
It means the owner can force the other owner to purchase their stock at a predetermined value or based on some formula.
Yeah.
And I think we had a put option used. We had a an appraisal, because I wouldn't do the appraisal because these people are my they're accounting clients, not
Right.
litigation clients. So we had another valuation person come in and do it. So in the put option, that same company would put a value on it, and she can put it back to him at her will after the debt's repaid. So there are ways you just got to look at, again, fact specific,
Right.
ways to get around that. But a good, well-drafted buy sell where one can get the other one out, is, I think, imperative.
Right.
Yeah. So what about, another problem of co-ownership after divorce seems to me to be that there can be these shareholder type derivative claims made against each other. And I mean, it just seems like the litigation could be just all encompassing forever and ever.
Yes.
That's a simple answer. Yes.
Well, yeah, I mean, you got Ritchie versus Ruby, which makes it harder to get an attorney to file one of those.
Right.
Because it's really difficult to get a shareholder derivative claim in Texas now.
Mm-hmm. And
But
tell us why that is.
The case pretty well made it very difficult for a
Yeah.
non-controlling shareholder to have any say over anything or
Right.
have any rights to anything.
Right. So the problem is now that the non-controlling sharebholders they just have to sit there and take it.
They're at the mercy of the controlling
mercy, yeah.
shareholder. And but I know there are a lot of attorneys out there that if they're offered
They're
a fee to go
trying.
harass their ex-spouse,
Yeah.
they'll take the fee to go harass their ex-spouse.
Yeah. It also seems to be counterproductive because the whole point of continuing to co-own this business together was so that you didn't tank the value of the
Right.
business. But if you continue to fight or, talk bad about your husband in town or, whatever, I mean, anything that you do that affects the value is counterproductive to the point of having this agreement in the first place.
I mean, unless the parties have a high level of trust at the end of their divorce, which is rare, I just don't see it working. You
Yeah.
might as well sell the thing.
But one thing I have seen where it does work is where they're a non-controlling shareholder or non-controlling partner, and you're able to take an assignee interest knowing someone else is making the distribution decision, someone else is making the operational decisions. And in hospitals is a good example of this.
Right.
Typically a doctor-owned hospital is run by a hospital corporation. They're the ones deciding when to pay the money out. They're the ones deciding how to make capital investments and do marketing and everything else. And if you have a well-drafted agreement to where you put them in as fiduciary role of those funds,
Right.
funds get paid to the spouse has to pay the funds out, and you put some tax language in to move the tax over. That works
Yeah.
because they're not controlling the company.
Right.
Right.
You don't have to
And
have
we've
faith
done,
in your ex.
And we've done several of those.
Yeah.
But it's a lot harder when they're the one running the
When it's
business.
closely.
Right, and yeah, I mean, I've had cases where we've had multiple corporations involved, and we've given them some sort of shares that don't have any voting rights or anything like that, and that way, yeah, they just sit there, they get their checks, and that's that. And
Yeah.
and that works out because they don't do anything. They've got fiduciary duties to everybody else in there, and that's that.
Yeah. So some sort of assignee interest or
Yeah, I mean,
Or
if you
profit
can
only.
create that fiduciary relationship associated with that assignee interest, and whoever the spouse isn't in control of anything, it works great.
Right.
It's
Yeah.
that control that creates the problem.
yeah. All right. So what about the situation where you have maybe a corporation where one spouse owns part of it with a person, not the other spouse? In other words, husband owns 50% with his brother, and then after divorce, husband and wife now own 50%, 25 each, and brother owns 50%. There's some problems fraught with even that type of co-ownership.
I've seen a lot of stuff, but I haven't seen anyone that had the guts to do that yet.
Well, I mean, there would be problems with that. That's why.
Oh, yeah.
Well, I mean, other brother isn't going to let it happen.
Yeah, right. Other brother would object to owning something with the brother's ex-wife. And then, there's also the risk of who gets mad at who in the family dynamics. And
Well, and if you put yourself in the non-working spouse's role, all they have to do is increase their salaries,
Yep.
and you have this flow-through income, and you'll never get
You're
a dollar.
done. Yeah.
Right.
yeah. So what are some strategies that you would recommend to people in dealing with this problem of the business is the major asset of the divorce, and we no longer can shift pre-tax money via contractual alimony, and we don't want to own it together? I mean, what are some other creative ways to deal with that?
I think what you're going to find is the payout is longer to buy the spouse out because of the tax issue.
Yeah.
And I haven't come up with any great creative solutions outside of that.
Well, and the problem with the payout is that it's bankruptable.
Correct.
I mean,
Yeah, I mean, you've got to secure it somehow, but
Yeah.
if there's no assets, then
I mean,
If you
try to
secure it with the
secure it.
business, the business goes under.
Yeah.
That doesn't help you a lot.
Right.
right. So
So what do we do?
Write a good CYA letter, I guess.
Yeah, and I guess that kind of falls into the category of, we're just lawyers. We aren't miracle workers. We can't solve every problem that exists in the universe. And this is one of the problems that exists in the universe as of January 1st, 2019.
That's right.
That's just hard to solve. And co-owning a business together isn't a great solution, and a payout over time isn't really a great solution for either side, and so there's just not really great solutions.
right. I mean, if I'm the attorney representing the non-operating spouse, there's no way I take the payout over time. But at the same time,
What choice do you
What
have?
choice do you
what
have?
choice do
I
I
mean,
have?
You got that or a judgment you can't collect.
Well, or
Which
you
one do
hope
want?
that there's other assets. I mean, I guess, the best case scenario would be that there's, a company worth $1 million and $1 million in a retirement account. And although apples aren't necessarily equal to apples, I mean, the bird in the hand of money, even if it is tied up in a retirement account, is better than having, some hope of a payout. And that would be about the best solution that you could hope for.
Yeah, and that works on the smaller businesses. But when you get a business where, and a lot of these successful entrepreneurs are illiquid. They
Yeah.
keep their money in their business because that's where they make their most money. So you have a business worth $10 million and you got a house worth $750,000 and $500,000 in a retirement account. You got no choice but to finance the purchase of that business interest.
Yeah.
Right.
I mean, there's just no
And-
other assets
And we see a
available.
lot of that because successful entrepreneurs are not typically liquid.
Right. Right. I mean, why would they be?
It's
If
not
they can
how they
make-
make their money.
If they can make more money having their business be more successful.
Correct.
Yeah. Yeah. All right. Well, that wraps us up for the Divorcing the Business Owner Entrepreneur webinar. Thank you all for joining us. We appreciate you being here. We hope you've learned a lot and commented a lot. Love your feedback on this program or any others that we've done or anything you think we should do in the future. We'd love that feedback. So thank you for joining us, and we'll see you next time. Keep in mind that this is a webinar that's aimed at attorneys. This is for continuing legal education. If you're out there watching this webinar and you're not an attorney, we welcome you to watch it. But remember that we are not giving you any specific legal advice. We cannot comment on any specific case or situation without knowing all the facts. So if you need legal advice, this webinar is not a substitute for legal advice. Please, please seek the advice of a lawyer as to your specific situation and get specific advice to that. Because if you rely on just what we're talking about here, we're being general, we're talking about general legal principles that may not actually apply to your situation. This is for continuing legal education only, and we cannot create an attorney-client relationship just through the video camera. Okay? Thanks.